5, 4, 3, 2, 1. Therefore, while remitting the matter back to the first respondent for consideration, I feel that the second respondent and third respondents should also be permitted to pursue their contentions about applicability, about the relevancy of exhibits M1 and M2 to the third respondent by adducing such evidence that may be available to them. It is also equally open to the petitioner to counter any such approach by adducing such evidence that may be available with the petitioner. On other aspect, which was also raised at the instance of the third respondent, was that under Exhibit M4, it is specifically provided that a transfer should not be effected by way of punishment and that a transfer should always be for administrative reasons only. According to the learned counsel for the third respondent, inasmuch as the petitioner has averred in its counter to the effect that the third respondent was alleged to have stolen firewood belonging to the petitioner on November 27, 1987 from the estate premises and that the same was reported to the higher authorities. There is every scope to construe that the order of the transfer issued under Exhibit M5 was not by way of administrative exigency but by way of punishment. The learned counsel for the petitioner would, however, contend that the averment contained in para 3 of the petitioner's counter in ID number 497 of 1988, though contains a narration of whatever events that took place on November 22, 1987, the only reason which weighed with the petitioner was the habit of the third respondent consuming alcohol and therefore he should not be permitted to drive a vehicle while he could be assigned some other job befitting his status without making any reduction in his salary, status or categorization. Inasmuch as I have decided to remit the matter back to the first respondent for consideration on the two aspects referred to, how with a view to give a fair opportunity to the third respondent, I am of the view that without prejudice to the respective contentions of the parties on the last aspect, the parties can also be permitted to agitate the said question, namely as to whether the order of the transfer under Exhibit M5 could be construed as one by way of punishment as has been stated in the relevant standing order, namely Exhibit M4. Therefore, while setting aside the award of the first respondent dated August 22, 1993, the dispute is remitted back to it for disposal on the above three aspects after giving due opportunity to the petitioner as well as the second and third respondents on the relative aspects by permitting them to let in such evidence both oral as well as documentary and dispose of the dispute within a period of 3 months from the date of receipt of copy of this order. No costs consequently connected. WMP is closed. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.